Welcome, everyone, to the University of New Mexico Law and Mental Health series, weekly discussions of practice and science featuring experts in behavioral health and the law. This series is run by the Division of Forensic Behavioral Sciences of the University of New Mexico's Department of Psychiatry and Behavioral Sciences in support with the New Mexico Behavioral Health Services Division. I'm Anthony Perillo, the Forensic Psychology Director here at the University of New Mexico. For our talk today, if you have any questions for our presenter, you can enter those in the Q&A box anytime you want. Do know that we hold questions until the end, and oftentimes it's not often possible for us to get through all of them. If you are pursuing continuing medical education credits, there will be a sign-in sheet posted right now in the chat box, so you can go ahead and register and sign in for that now. If you are pursuing APA continuing education credits, the link for the survey you'll complete for those certificates will be near the end of the webinar, but also in the chat box. So keep your eye on the chat box near the end of the presentation, getting close to the top of the hour. Bookmark or otherwise open that link before the webinar closes, and make sure that you save your certificate after you complete the survey. We don't have completed certificates after the fact. The recording for this week's talk should be available on our YouTube channel sometime later this week, and a copy of PowerPoint slides for those that have registered for the series will be available later this week as well. And as a heads up, next week we have Dr. Cynthia Calkins who will be discussing clinical evaluations of people with child pornography offenses. But getting back to this week, I'm excited to introduce you to today's speaker, who'll be discussing nuances in assessing competency for defendants to represent themselves. This is Dr. Alexis Glomski. Dr. Alexis Glomski is a forensic psychiatrist. She completed her psychiatry residency at the University of Louisville and a forensic psychiatry fellowship at Case Western Reserve University Hospitals. During her training, she studied and conducted a variety of forensic psychiatric evaluations, including competency to proceed pro se. She is currently practicing as the clinical director at a state hospital in Minnesota. So, Dr. Glomski, Alexis, on behalf of the University of New Mexico, thank you so much for joining our series, and I'm thankful for you sharing your expertise with all of us today. I will go ahead and toss it over to you.
Okay, thank you very much for having me today. So let's go through some basic introduction here. Here's the CE information if you need that. Disclosures, I do not have any disclosures to announce. Disclaimer, the views expressed are of my own and do not necessarily represent the views, policies, and positions of the University of New Mexico. So today we're going to talk about competency to proceed pro se or represent oneself in court. And we're going to go through a variety of elements when we're looking at how to do those assessments. So we're going to think about how and to what extent certain mental health symptoms could interfere with someone's ability to represent themselves. We'll talk about the different elements of competency to proceed pro se, going from the ability to consult and assist in one's own defense to actually conducting one's own defense. And then we'll also look at a case example and give you guys a chance to think through that and what your opinion might be of whether or not that defendant is competent to proceed pro se. So when we think about criminal competencies, there's several. Here's a list. It's not exhaustive. There are others. But today, what we're going to focus on, we'll touch on competence to stand trial just a little bit. And then the bulk of what we're going to talk about is competence to represent oneself, also known as pro se. So when we think about competency to stand trial, this is one of the first things you learn in forensic training. So I'm sure many people are quite familiar with this at this point. But the landmark case that's most important for competency is going to be Dusky v. US from 1960. And this is the Supreme Court case that set the national standard for what it means to be competent to stand trial. And in this case, they said that the defendant must have a rational and factual understanding of the proceedings against them. And they also must have sufficient present ability to consult with a lawyer with a reasonable degree of rational understanding. And this is known, as far as criminal competencies go, to be a relatively low threshold to meet. And then when we look at competency to proceed pro se, that you have to be competent to stand trial. And then it goes a step further than that. So somebody has to be able to do things beyond just being competent to stand trial. They have to also be able to waive their right to legal counsel, and they have to be able to represent themselves in the proceedings. And so as we continue through this lecture, we'll touch on what exactly those extra tasks entail and how we assess whether or not the defendant can do those things. And when we think about this competence to proceed pro se, we have to consider the history of it, the cases, where it comes from and why we have to do these evaluations. And so it starts with the Sixth Amendment, which guarantees the right to counsel in these court proceedings. By the same token, it also guarantees the right to self-representation if that's what the defendant chooses and is able to do that. So Ferretta v. California from 1975, this is a US Supreme Court case. And essentially what this case did was affirm that there is a constitutional right to waive counsel if the defendant is competent to do so. And so the court said when making this decision, the defendant has to do it knowingly, voluntarily, and intelligently. They did not give an actual competence to proceed pro se standard, but they did note that someone is not incompetent merely because they may be unable to understand technical legal matters. And what they said was that although a defendant may ultimately be acting to their detriment in choosing to go pro se, the value of free choice is worthy of constitutional protection, even when the choice could increase the likelihood of criminal punishment. Next, almost 20 years later, in 1993, the Supreme Court heard another case, Godinez v. Moran. And in this case, the Supreme Court said the standard for competency to plead guilty and to waive counsel is no higher than the standard that was set in Dusky for competency to stand trial. Now, because they're making a decision, they also have to be doing it voluntarily and knowing. And the court said a criminal defendant's ability to represent himself has no bearing upon his competence to choose self-representation. So the court is making this distinction between someone having the ability to make a choice versus somebody actually being able to do that task of representing themselves. And it doesn't necessarily mean that's the same thing. And then we have Indiana v. Edwards from 2008. And this is a case where the Supreme Court came in and they said, well, we're not going to set a specific competency to represent oneself standard, but states are allowed to create a standard that is higher than just simply the standard for competency to stand trial. So just as kind of a summary of what we talked about, here are the different competencies. Competency to stand trial, to waive counsel, so to choose that they don't want counsel, to plead guilty, and then to actually represent themselves. And you can see all of them at the baseline, they have to meet that Dusky standard. And then in that far column to the right, you can see the extra that's sort of tacked onto that. So for waiving counsel and pleading guilty, they have to be making a voluntary and informed decision beyond just simply meeting a Dusky standard, as is the standard for competency to stand trial. And then when we progress to the bottom of representing oneself in court, we see how Indiana v. Edwards comes into play and adds this optional functional component where there can be a higher threshold allowed when evaluating whether or not somebody is competent to represent themselves. And that tends to be what is used in the United States today, is this basic Dusky, but also they need to have these functional components and this recognition that representing oneself in court takes higher level functioning higher level behavioral capacities than just simply standing trial. And then we also have this other case from 1984, McCaskill v. Wiggins. And this case kind of is right in that gray zone where they said a defendant might be competent to proceed pro se, but the court can choose to still appoint a standby counsel. And when this happens, the defendant has to continue to retain control of the case, and the standby counsel cannot interfere with the defense that's presented. So situations in which the court might want to do this is when someone maybe meets the criteria, they are competent to represent themselves, but maybe it teeters on the line a little bit. Maybe there's some signs that they have some cognitive strain when they're under pressure, or they have some trouble sustaining attention or organization potentially in the long term. So just something that kind of raises the court's suspicion that they might at some point during the course of the trial need somebody else to step in and take over for the defendant, or need somebody to help sort of just guide things and make sure that the defendant is still getting a fair trial. So going a little bit deeper here, we have the capacities that are required for consulting and assisting. So this is what's under that Dusky standard for competence to stand trial. And in order to meet that, someone needs to have a basic understanding of the legal system. So basically understanding, a simplified version at least of who the courtroom players are and how things interact and, what's a trial. They need to appreciate their own legal situation. So that could be, an understanding of what are their charges and what are the potential consequences if they're found guilty. They need to be able to communicate with their attorney and make reasoned decisions. They need to have sufficient behavioral control to be able to be present in that courtroom setting and have some intact memory and attention to be able to pay attention to the courtroom proceedings and to interactions with their attorney and be able to give, feedback on what they want to do with their case. When we're thinking about mental health and how that could interfere with the ability to consult and assist, there's three main areas where they can have trouble. One is going to be the inability to understand the legal proceedings. So this could be somebody with a cognitive impairment. They can have difficulty understanding maybe a psychosis that impairs their ability to understand and have, reality-based thoughts. They can have trouble assisting in their defense. So again, this could be a psychosis, maybe a paranoia with their attorney, so they can't really work with their attorney to form a defense. Maybe they are manic and they're very, impulsive and behaviorally difficult to manage, and so the attorney can't, really work with them. They could have trouble making informed decisions, and this again could be anything from a cognitive impairment that gets in the way of their understanding. It could be a psychosis, not being in reality, so they're not able to make rational decisions. And now we're going to go to preparing and delivering a defense. This would be really what we're here to talk about today with the competence to proceed pro se. What is required to be able to do that? And we have three overarching kind of key capacities. There's cognitive capacities, there's communicative capacities, and then emotional and behavioral capacities. When we look at cognitive capacities, we want to think about the ability to understand their charges, potential penalties, and the trial process. And this goes deeper than just what is required for competency to stand trial, right? They need to have a deeper understanding of what goes into the trial process. Where do they fit into that? And what kind of tasks are they going to have to take over in place of their attorney to make that trial move forward? Do they have the capacity to make rational decisions regarding a defense strategy? Again, a step further than just competency to stand trial, because now they need to make these decisions on their own. They don't have somebody necessarily coming and presenting them, two choices. What do you pick? Or walking them through the choices and why it may be good or might not be. They have to be able to come up with that on their own. Do they have the skills to be able to present a defense? And this can include things like having to question witnesses, present evidence, and argue the case. Then we think about the communicative capacities. They need to be able to effectively communicate with the court, jury, and witnesses. So now, again, a step beyond competency to stand trial, they need to communicate to everybody else. It's not just to their attorney, who can then, communicate it in a more coherent and effective way to all the other court players. The defendant has to be able to do that themselves. And they need to have oral and written communication skills, because they need to be able to, in the courtroom, orally express themselves, and then also be able to do other functions such as writing motions, which is going to include those written communication skills. And when we think about the emotional and behavioral capacities, do they have the capacity for rational and goal-directed behavior? Again, they're not going to have that attorney in the middle that can help, kind of interpret what they're doing and guide what they're doing into a manner that is actually effective in the courtroom. The defendant has to be able to do that on their own to achieve their desired outcome and move the case forward through the court process. Do they have the ability to manage their emotions and stress in a high stakes environment? If they're going to be the one in the courtroom, they're going to be the one presenting their case and filing the motions. That's a lot of stress. That's a lot of pressure and a lot of eyes on that defendant. So are they able to manage that without the buffer of their attorney, taking on all of those big actions for them? So now we're going to talk about evaluating people for competency to represent themselves. And much like any other forensic evaluation that you would do, you're going to look at records, you're going to look at collateral information, and this could include information about how they have behaved in the courtroom thus far in their case. So that could come from, conversations with their attorney. You could also get collateral from jail staff if they're housed in jail. Psychological testing, if it's indicated, and then, of course, your clinical interview. And when you do your interview, it's really helpful to do mock scenarios with the defendant. So, and it could be their case or it could be a made-up case, but present them with a scenario and ask them, what is your next step? What's your decision in this case and why? And then you can take it a step further and sort of extend that scenario to, okay, you made this decision. Now this is what happens. Now what are you going to do? And see, again, do they have reasonable, rational thinking? And also, how flexible is their thinking? When the outcome is different than they expect, can they change their thinking and change their strategy in the moment? And you want to think about these three kind of overarching questions. First, you want to assess, do they knowingly and voluntarily waive their right to counsel? If they don't, if they can't do it knowingly and voluntarily, then proceeding further into assessing their ability to represent themselves doesn't make sense, because obviously they can't choose to do that. Can they meaningfully engage in making legal arguments, examining witnesses, following court procedure, filing motions, and responding appropriately to rulings? So this is starting to look at those functional capacities that somebody would need to have to be able to represent themselves. And then third, and very important, is going to be, do they understand the risk of self-representation? So when we look at the legal abilities of the defendant, we want to think about, can they explain to you what a trial is? Can they explain how they are involved? Do they understand the tasks of an attorney? Do they understand what they're taking on by choosing to do this? Can they grasp the gravity of the charges and potential consequences? And then you want to look at their decision making. So can they articulate a basic defense strategy? Again, they don't have to be an attorney. We don't expect legally perfect and complicated defense strategies, but can they at least describe to you what their intended strategy is, what they think the outcome of that would be, and why they're choosing that strategy? And can they explain in a rational manner why they want to represent themselves? And this is again where those mock scenarios become really helpful. So you can give mock scenarios about plea deals, or choosing whether or not to go to trial, or choosing whether or not they waive certain rights, and you can get a good sense of how do they understand that decision-making process? How do they make their decisions? And again, is it rational and based in reality? And their motivation to do pro se. So you want to know why. Is it reality-based? And is it rational? You don't necessarily have to think it's a good decision for them or agree with it, but you're just making sure that it's based in reality and it's reasonable. Is it free from coercion? And so some of the reasons people might choose to go the route of self-representation that could be considered, reasonable. It might be that they don't really trust attorneys because of maybe bias they've experienced, or prior negative experiences working with attorneys. You hear that a lot, specifically with people that work with public defenders. They might feel that their attorney can't convey the message that they want and that they're the best to convey that message. They might disagree with the strategy that their attorney wants to take for their defense. And so obviously you want to, get into the nitty gritty and the details of why that's their reasoning and make sure it's reality based. But people can have very rational reasons for choosing self-representation. And then you want to assess their knowledge of the risks of self-representation. So they need to understand that, they're not an attorney. They don't have that same knowledge. So they might not present as effective of a defense. And they might lose certain legal protections. And so do they understand that? Looking at their cognitive abilities, can they stay engaged in the duration of the trial? Right, if we're just looking at the competency to stand trial, they need to be engaged and they need to be able to follow the trial, but maybe not quite to the extent as they do if they're the one presenting the defense, and they need to be actively, remembering everything that happens in the trial and engaging with witnesses and cross-examinations. Looking at their communication, so you want to assess, can they explain their case and their intended defense strategy in a clear and coherent manner? Can they stay on topic when they're talking about their case? Can they present logical arguments? And it's important when they are describing their defense or their case to ask additional questions, because sometimes they might superficially present something that seems reality-based and coherent, and then you start asking questions and poking holes in it, and then their thought process can just really derail, and it can show you they're not actually thinking in a clear and coherent manner. Emotional and behavioral, you want to assess their ability to handle stress, criticism, and challenging moments without losing control. So you want to think about their behavior with you, their behavior during prior courtroom experiences, and just in general, what is their pattern of behavior? Do they typically, maintain their composure in stressful situations? Do they have ways to deal with stress? Or do they tend to have angry outbursts and things like that? So here's a very simplified decision tree for these types of evaluations. First step, you're going to want to ask, are they competent to stand trial? If they're not, there's no reason to move forward with a pro se assessment. They need restoration to competency. If yes, then you move forward to, do they want to waive counsel? Obviously, if they don't, then you would not need to do a pro se evaluation. And then you're going to look at, for number 3, are they able to, again, knowingly and voluntarily waive their right to counsel? So do they understand the charges in court process? Do they understand the risk of going without an attorney? And do they understand the court's not going to help them in preparing their defense? If yes, then you can move forward to assessing those more nuanced functional capacities that are needed for self-representation. And that's where things like the ability to communicate clearly, organize and present arguments, follow court procedure, things like that come into play. So thinking about mental health and how mental health symptoms can impair this ability to represent themselves. If we think about someone that has a psychosis, so as you can imagine, it can affect a lot of these very important areas we've talked about. Some key ones would be if they're having disorganized thoughts and speech, they're going to have difficulty communicating clearly with the court. Their arguments might be incoherent. They could have difficulty presenting a clear choice to the court, and difficulty like attending to and responding in a coherent manner to the prosecution's arguments. If they're experiencing hallucinations and delusions, this is probably going to impair their ability to make reality-based and rational arguments and decisions. They could have inappropriate behaviors in court, so they could be behaving in ways that are paranoid, or they could be even responding to their hallucinations. And they very likely might misunderstand information that's presented in court and the procedures that they need to follow. They also tend to have poor insight and judgment. So this can affect their ability to make decisions for themselves and decisions that would be in their best interest and would be what they would want for themselves if they were not having symptoms at the time, and can get in the way of forming a productive legal strategy because they might underestimate or overestimate the success of whatever defense strategy they come up with. And a sort of side category to that that's important to know about when you're doing these assessments is extreme overvalued beliefs. So these are beliefs that are shared by others in a person's cultural, religious, or subcultural group. And over time, these beliefs tend to become more dominant, more refined, and more resistant to challenge. They're held with conviction. And one that comes up a lot in these evaluations is sovereign citizens. So a very sort of basic definition of the sovereign citizens is they believe in an alternate American history and alternate laws. So they might understand like the mechanics, the basics of their legal situation, knowing what they're being charged with, but they believe they're outside the jurisdiction of the court, or that the charges are illegitimate, or the rules of the court don't apply to them. So when you're thinking about whether or not somebody is competent to proceed pro se and they have these sovereign citizen beliefs, it can get really difficult. You can have the person with these beliefs that recognizes the majority of people, the majority of the country don't agree with them. And so, you know, they are in a court that is under traditional United States laws. And even though they don't agree with those laws, they're willing to work with it and follow the traditional procedures of the court. On the other hand, you might have somebody who is not willing to do that, and they're very insistent that these charges are not legitimate. I am not under the jurisdiction of the court. I don't have to respond, you know, to the court's requests for me to do X, Y, and Z. And when you get to that point, it becomes very difficult for that person to be able to represent themselves in that knowing manner and to really understand what's going on with their case. Going back to other mental health symptoms, so mania, they tend to have difficulty communicating because their speech can be disorganized and pressured with flight of ideas. And so this is going to get in the way of presenting coherent arguments and defenses. It can get in the way of forming rational decisions and presenting those to the court. They're often grandiose, so they're going to be often overconfident. They may underestimate the complexity of the legal procedures or dismiss the need for legal support entirely. They can be impulsive, so they could demonstrate inappropriate courtroom behavior, which is going to, diminish their credibility in the eyes of the judge and the jury. They could end up disclosing damaging information, and they could also file many erratic legal motions that's very confusing and not helpful to their case. They're often distractible, so they could be easily thrown off by any minor interruptions in the court procedures or by irrelevant thoughts, which can kind of come into play again with those flight of ideas. As a result, they could miss important objections. They could fail to address inconsistencies in witness testimony or procedural errors that come up. They can be irritable when they're manic, and this can result in disruptive behavior in the court or in unproductive interactions with the judge and the prosecutor or witnesses. And as a result, they could also fail to adhere to proper courtroom procedures and decorum, which again affects their credibility in court. Also, the decreased need for sleep. So eventually that can catch up to them and they can feel fatigued. They could have cognitive overload because there's so many thoughts racing through their mind and they're not sleeping. And this can result in mental exhaustion mid-trial and just really throw off the trajectory of their course. Someone with depression. So people with depression tend to have low motivation. They could struggle to complete the basic legal tasks required, such as reviewing evidence, drafting motions, or preparing witness questions. Again, the poor concentration and attention, so they can miss critical events, deadlines, or procedural requirements. They often can have impaired decision making, so they can be indecisive. Their decisions can be driven by pessimism or avoidance rather than really thinking about, logically what's going to benefit them in the long run for their case. They can feel hopeless and basically just give up on their case or fail to advocate for themselves. They can have passive behaviors or self-sabotaging behaviors. And they can also sort of just refuse to engage with the process because they just feel like it's not worth it, it's hopeless. The social withdrawal that is seen in depression can result in difficulty communicating in the courtroom. So they could have trouble with questioning witnesses, confidently addressing the court, or advocating for themselves in an effective and persuasive manner. Then we have anxiety disorders. Again, the difficulty focusing and maintaining attention comes into play. They can have impaired decision making, more on the spectrum of overthinking and fearing that they're going to make the wrong decision. So they can really end up hesitating in making decisions due to just like feeling frozen and overwhelmed by all the information and the pressure of the trial. If they have panic attacks or physical symptoms of anxiety, this can be very distracting to the defendant. It can prevent them from fully focusing on the trial, from fully participating in their own defense, and also potentially, if this is observed by the judge or the jury, it could make them appear unfit to be representing themselves, and the jury might lose confidence in them as a defendant. And then a lot of times with anxiety, very commonly, they might have social anxiety or fear of public speaking. Pretty straightforward. This would really impair their ability to communicate effectively and confidently and clearly in court. and hinder their ability to advocate for themselves. They can feel very self-conscious potentially, maybe even bordering on paranoid, resulting in avoidance behaviors. So they might not engage in cross-examination of witnesses, or they might not make objections. They might avoid making key decisions or pursuing certain defenses because they're fearful of being wrong or criticized for their choices. And then just simply the cognitive overload. So there's a lot of demand on the defendant when they're representing themselves. And then if they have this anxiety on top of that, they can get to this point where they just are so overwhelmed by the complexity of the trial or the volume of information that they have to take in and manage, that they just really can't effectively respond to it all, and they basically shut down. Trauma disorders can come into play as well, depending on what the trauma is and what the content of the case is. They can potentially be triggered by the content of the case. This can lead them to feel very, overwhelmed. It could result in emotional outbursts in reaction to this trigger, panic attacks, or even dissociation, where they just, they shut down and they no longer are taking in all of the case information, and they're not able to track it and then make decisions based on that new information. They may have a lack of trust of other people, which can cause them to reject counsel, refuse to cooperate with legal procedures, or maybe even misinterpret actions that occur within the courtroom and between court players. And then cognitive impairments. This one seems a little bit more straightforward, maybe. So if they have memory deficits, this is going to be very difficult because they're not going to be able to keep track of the proceedings and take in that new information and then use that to then make decisions about their case. They might have trouble recalling and following instructions of the court. Again, they can have attention deficits, so they might have poor engagement with the trial and not take in all of the information that's being presented. They can have trouble with problem solving, and this can show up with them having difficulty organizing their thoughts, formulating effective legal strategies, or responding appropriately to complex case issues that might come up. And they might have trouble anticipating also what the prosecution's tactics might be. So they have difficulty then responding when the prosecution, takes their case, their argument in a certain direction. They didn't anticipate that, and they don't know how to respond to that in a way that still effectively argues for their defense. They can have difficulty with language and communication, so struggling to articulate legal arguments clearly, which can lead to confusion within the courtroom, and just, a lack of effective communication with the judge and the jury. And they can have also impaired abstract thinking, which is going to hinder their legal decision making, or it could impair their ability to understand important concepts like legal strategies or the gravity of their criminal charges. And then if they have a slower processing speed, that can make it difficult as well to respond to the multitude of things that happen within a case. If there's a sudden change in the strategy by the prosecution or an unexpected legal ruling, they might have difficulty responding to that in an effective way. So if we think about this comparison between competence to stand trial and competence to proceed pro se. As we reviewed, competence to stand trial requires basic cognitive and communicative abilities in order to be able to understand and participate in the legal process with the help of an attorney. Competence to proceed pro se requires higher order functional, legal, and behavioral capacities, because now the defendant is fully responsible for conducting their defense without counsel. So they need to be able to do more than if they're getting that assistance and that guidance from their attorney. And just some ethical considerations for these evaluations. Really the purpose of having a system to be able to assess competence to proceed pro se is to balance autonomy and paternalism. We want defendants to be able to make decisions about their case, and do what they want and what they think is in their best interest. But we also have to balance that with maintaining the fairness of the courtroom proceedings. And it obviously would not be a fair trial if someone who is floridly psychotic and doesn't understand their charges at all to be representing themselves in court. When we're doing the evaluations, we need to make sure that we're maintaining objectivity and impartiality. And part of what goes into that is recognizing any potential biases we might have, and also being culturally competent and sensitive. We need to take all of that into consideration when we're assessing, their decision making and what they want the outcome of their case to be. And it's also important to remember, poor judgment does not equal incompetence. You do not have to agree with the defendant. You do not have to think that they are choosing the best route for themselves. It's about what they want to do, what they believe, and whether they have the capacity to pursue that choice and actually represent themselves. So now I have a case example I'll go through. And while I go through it, I just want you guys to kind of think through it and what would be your opinion on this case. And maybe people can put in the chat or in the Q&A, can kind of just voice what their opinion might be on the case. So we have a defendant, John Doe. He's a 26-year-old male, former computer science student. He's charged with computer intrusion, possession of hacking tools, and identity theft. He allegedly accessed a university's grading system and altered transcripts, including his own. He has no prior criminal record. However, he did represent himself in a campus misconduct hearing effectively, and now he is demanding to do so in court for this case. He's diagnosed with autism spectrum disorder. His IQ is in the superior range. He has no psychosis, mood disorder, or cognitive impairment. He displays pretty literal thinking, poor pragmatic language use, so he has trouble understanding sarcasm and implied meanings. He has significant difficulty with social cues, emotional nuance, and flexible reasoning. He tends to have a fixation on irrelevant procedural details as well. He speaks in monotone, maintains minimal eye contact. He did file some pretrial motions, and they were all very well written, precise, but they were procedurally incorrect. He corrects the judge's legal terminology during hearings and refuses to answer open-ended questions without further clarification. He is requesting to represent himself because no one can understand the technical parts of the case but me. His public defender tells you he's smart, but he refuses to listen. He doesn't understand when we're trying to help him. It's like he can't read the room. During your interview, you notice that he can define legal roles and terms with precision. He insists on being correct, even when he's shown contrary case law. He cannot paraphrase the court's goals or the risk of self-representation beyond surface level responses. And he fails to anticipate how a jury might interpret his tone or demeanor. So I'll let everyone kind of think about that case. And what your opinion might be, or maybe if there's something you would want to do, a test that you might want to conduct, or additional information you feel like you would need to make an opinion about him. So in summary, not all defendants who are competent to stand trial are competent to represent themselves. When we are conducting competency to proceed pro se evaluations, mental health professionals must parse out nuanced impairments in reasoning, communication, and decision making. And now we have time for some questions.
Well, thank you so much, Dr. Glomski, for just a really eye-opening perspective on an issue that we don't really conventionally discuss, but seems would be quite relevant to a lot of cases here. We do have a couple of questions here at the moment. In the meantime, of course, if you have any other questions related to this, you can enter them in the Q&A box or your perceptions on the vignette in and of itself. The QR code and the link for the APA CEU surveys will be up shortly, so keep your eye in the chat box for that. A couple of people have asked about the context of when this could or should come up for an evaluation. In particular, somebody's question here represents a couple of questions that we have here. Somebody said, do courts ever specifically request the evaluation for competency to proceed pro se, or is this typically just incorporated into a competency to stand trial evaluation? If you think someone's competent to stand trial but is insistent on going pro se, should you then evaluate their competency for it there in the moment?
That's a really good question. And I think probably it varies a little bit jurisdiction to jurisdiction what people tend to do. But yes, they will order specific competency to proceed pro se evaluations. So I know, like in Ohio, where I did my training, a lot of times it would start off with a simple competency to stand trial evaluation. And then we would see them, they would be competent, write your report, and then they would end up coming back a few weeks later for the competency to proceed pro se evaluation. I think if you're concerned about somebody's competency to proceed pro se, it might be worth more so contacting the attorney and just saying, hey, do you have any intent to pursue this evaluation? I think it can get a little bit hairy if you're ordered to do a competency to stand trial, and then you sort of take it that extra step without the court actually asking. I would personally want that formal request from the court.
Gotcha. Thank you for that. I'm gonna tack on a question to the question that somebody has here. They're talking about a specific evaluation that they have, and they're saying, I'm currently in the process of completing a competency report on a pro se sovereign citizen who declined to participate in the evaluation. He didn't consent to the court order. He's receiving mental health treatment, did not appear to be psychotic or demonstrating any symptoms of mental illness. I guess my question on top of this is, what is the burden of proof generally when we're thinking of competency to proceed pro se? Does somebody need to demonstrate those abilities, or is there a presumption of competence unless there's impairment or legitimate concern?
So I would say, because again, it all derives from this competency to stand trial standard. And so when we're talking about competency to stand trial, there's this presumption that they are. And so for pro se, I would say that presumption continues to exist. And so you would need to see factors more so that take away from that ability, instead of having to be able to prove, yes, I can do this. Because again, we're not expecting them to be an attorney or to have that level of legal ability, in which case, right, as we do with attorneys, we want them to prove they have that ability, and that's why we have bar exams and things like that. But for a traditional person, someone that wants to pursue self-representation, we can make the assumption that they have abilities to communicate clearly, to make rational decisions. So unless we have evidence to prove otherwise, I think we would make that assumption that they would be competent.
You actually brought up in your scenario this issue here, but somebody asked earlier in the webinar, they'd like to know how your process in this approach might differ with somebody on the autism spectrum, or how does autism spectrum come into play here?
Yeah, it's a tough one. And it really, right, depends what level they're at on that spectrum. I think you might conduct your evaluation a little different, taking into consideration that they are on the autism spectrum and, maybe they don't understand social cues and nuances. And so you might present questions in different ways, more concrete ways that they can understand. But by that same token, you have to remember the courtroom isn't necessarily going to do that. So they can have, some deficits in this social understanding, but if it's to the point where you are changing your questions so extremely for them to be able to understand and interact appropriately, that's going to interfere with their courtroom experience and their ability to engage effectively with the court.
How would individuals with personality disorders, wherein they feel as though they are superior or know more than their lawyer, even if questions from an evaluator or judge show limited knowledge of the legal system, impact competency to represent themselves?
I view that similar to the sovereign citizens, where it's very much on a spectrum. How severe is it? If it's so severe that I'm absolutely superior, I don't, need to follow what the judge tells me to do, I know better, that's clearly going to interfere. They need to at least be able to cooperate with the court process to move their case forward. But if it's on the more minor spectrum and they're still able to at least cooperate with the basic court procedures and do what they need to do, then that would be acceptable, you could say.
Legally speaking, if a person ultimately does defend themselves, can they later claim inadequate defense?
That's a very good question. I actually do not know the answer to. I would have to look that up.
Perhaps some of our legal professionals in the audience might be able to clarify that one. I am admittedly ignorant on that issue as well. Um, someone said you referenced cultural competence and ethical considerations. How do you navigate the boundary between respecting a cultural belief if they insist on their cultural worldview, if it conflicts with principles of the U.S. legal system?
I think, again, I'm going to reference back to the sovereign citizens. I think you can respect it, and there might be certain cultural beliefs that the court can make adjustments for how they do their procedures and kind of work with that defendant, and you can suggest that in your evaluation and your report to the court. But again, you have to think about how severe is it and is it impacting their ability to make reasoned decisions, giving the reality of their court case and what has to happen for their case.
Do you have a suggested list of questions, or how have you identified questions to ask people who desire to proceed pro se?
I don't have a specific sample template or anything that I found somewhere. I really have, sort of the template of things that I ask for competency to stand trial. And so I would go through those. And then I just really tack on more detailed questions about like the defense strategy and their understanding of the case. And I think sort of the method where they answer a question and you follow up with questions, right? Just like build off of a question is really what's most helpful because that's where you can start to find those holes. A lot of times they can answer superficially what their defense strategy is, but unless you start poking into the holes and really examine that answer further, you might not, you might not find out that they're not actually rational and coherent in their defense strategy.
We have at least one person saying, at least in their state in Illinois, that you cannot claim ineffective counsel if going pro se. So at least that's one state there. I don't know about any other ones at the moment. Somebody asked more about general rates, if you're aware of any. Like, how frequently does this come up? How frequently is there a request to evaluate pro se in relation to competency evaluations? And when it does happen, do we have any idea roughly how frequently somebody is found competent pro se?
So I don't have any like hard and fast numbers on it. Obviously, as we know, it's a pretty rare evaluation in the grand scheme of forensic evaluations, and I do think it tends to differ a bit, like jurisdiction to jurisdiction, just based on the attorneys and the judges that are practicing. Because I think, in some areas it might not be very common to have this evaluation, and in others it's sort of a standard practice for them. Every time somebody requests pro se, let's just double check, let's get them evaluation and make sure. So I think it does vary a bit based on that.
Fair enough. Thank you. Somebody noted, we often have our own scenarios or hypothetical scenarios we use in competency to proceed evaluations. Are there any particular scenarios or hypothetical scenarios that you use in these evaluations that are meaningfully different than your standard competency to proceed evaluation?
I don't have any standard ones. I think the most helpful ones are related to their case and assessing that flexible reasoning. So that's really where I find it most helpful is, let's say, for example, they give you their intended defense strategy and coming in and saying, okay, but what if the court says this? What are you going to do? And really assessing that flexible reasoning. But I don't have any like specific scenarios that I ask everybody.
And at the moment, is it your understanding that there really are no standardized instruments to assess pro se competency?
Yeah, all the standard is just for general competency to stand trial, which can be helpful, but it's not specific to pro se.
Yes, certainly. Somebody asked if children, if somebody, if a child or a legal minor asked to proceed pro se, are they allowed to, and how you would evaluate children in that scenario?
That is a very good question. I am not a child and adolescent, so I would not choose to evaluate them. But to be honest, from a legal perspective, I am not sure that an adolescent would be able to.
Gotcha. Could you please speak about how work product privilege does or doesn't apply to competency to proceed pro se evaluations?
Can I have an example?
I could try to think of one, but in the meantime, if our questioner for that has one, I'm happy to add to that about scenarios in which work product privilege would or would not apply to competence there. In the meantime, I will throw it out to, well, you already said there aren't none there. Somebody asked if somebody's reasoning for wanting to represent themselves is because they do not have adequate funds to pay for what they consider a good attorney. Would you say their decision is free from coercion, or would money be a coercive factor?
That's an interesting question. I would generally say it's free from coercion. I think, obviously that went into a factor of their decision, but there's always going to be something that's driving your decision, right? So I don't necessarily think it's coercion. And that's sort of one of the reasonings that tends to be considered reasonable. Maybe they don't qualify for a public defender for some reason, or they just really don't want them, but they can't afford an attorney that they think is going to represent them well enough.
Gotcha. We do have a recent comment, somebody that'll come up in the Law Mental Health series later this year, that it's my understanding that in most jurisdictions, pro se is not an option for juveniles, but if they are a minor charged as an adult, that might be an option open to them at that point. We are at the top of the hour. Dr. Glomski, I appreciate the responses to the spitball line of questions have here. You could see that this is an area that a lot of us are fairly unfamiliar with, despite our knowledge in this area. So a lot of thoughtful questions, a lot of helpful information here. I really appreciate all the work you do in this area, as well as sharing this both conceptual, legal, and practical considerations if this comes up in any of our practices. So thank you so much for that expertise. That does wrap up this week's Law and Mental Health series. Next week, we hope that you can join us when Dr. Cynthia Calkins will be talking about clinical evaluations of people with child pornography offenses. We hope to see you then for another great discussion of issues in behavioral health and the law. Until next time, take care.